Morning, everybody. It's 8 a.m. It's Thursday morning, and we are going to talk about force majeure and risk of loss today. I hope everyone is having a good morning. My name is Sam Saad, and like I said, today's topic is force majeure and risk of loss under the NABOR and FARBAR contracts. I am an attorney here in Southwest Florida, as many of you know. So, of course, we'll start off with my disclaimer that I'm providing you legal advice, but it's not legal advice, and no attorney client relationship is created. And if you have any specific legal questions, you need to consult with me or one of my attorneys separately. Just a little bit about me and the firm. I have been an attorney for over 20 years. I am the past chair and current scribe of the NABOR Legal Resources Committee. So I often joke, you say, who writes this stuff? Well, I do. Uh, and I'm a member of the FARBAR Joint Contract Drafting Committee, which is the FARBAR contract uh, overlords, I like to call them. My firm focuses on real estate, business, litigation, probate, and estate planning. We have 5 lawyers to serve you and your customers, and we have offices throughout Southwest Florida. For all your closing needs, you can use Paradise Coast Title and Escrow. It's the best option for your customers. We guarantee will be the lowest closing fee. We are always up to date on our crazy industry with all of its changes, which is part of some of my future contract videos are going to be on the changes to the contracts that are coming up at the end of the year. We're always up to date on security, and I'm really excited that we're going to be using Qualia Connect to enhance the security for your customers. And if you have any questions about our closing services, you can call me on my cell phone, 239-784-5556 anytime. So today we're talking about risk of loss and force majeure clauses under the FARBAR and the NABOR contracts. So we're going to start with NABOR's risk of loss provisions. It's very interesting. I want to show you what it looks like. This is the complete NABOR risk of loss section, standard D3, and we're going to break it down into bite-sized pieces. What you have here, I want to describe how this works. You have sections D3A through F. They are separate provisions that kind of work together. So they define what a casualty is in the event of a firestorm, flood, extreme weather condition, or other casualty occurring between the effective date of the contract and the closing date or date of possession. That's a casualty. This is very important to understand this definition, because if you had a hurricane that happened before the effective date or after the closing date or date of possession, you don't have a casualty, and these provisions don't apply. So it's a very narrow time frame for when you would dip into these provisions. And I made some bullet points here to talk about these provisions for you. Basically, if there is a casualty, the seller must fix the damage. Um, there is a limitation of 1.5% towards the landscaping, but there is not a provision to limit the seller's liability in the event of catastrophic damage to the property. Although, if the buyer can't get insurance at a reasonable rate, and that's going to be a question as to what is a reasonable rate because of the casualty, or if we cannot close because services essential for closing are not available, then you can delay the closing until 5 days after services are restored, but not more than 30 days after the hurricane passes. So just breaking that down for you a little bit, on the NABOR contract, you're looking for a reasonable rate of insurance. What does that mean? I don't know. The judge knows. What is reasonable? It's a difficult term to deal with, but it is what the contract says. I will tell you, if you can get insurance under Citizens, I would argue that's reasonable enough because that's the state insurance rate. But of course, that's a higher coverage or higher rate of insurance, and it's less coverage. So I can't say for certainty that just because you can find a citizen's policy, yes, doesn't mean that it's reasonable. The other thing about the NABOR contract, if on the closing date the property is uninsurable or uninhabitable, then either party can terminate the contract. So that's going to be a tough one if the hurricane comes through and we're on a short close. After the casualty, you're allowed a post-casualty inspection. This is a limited inspection to identify damage or loss, but the seller notifies the buyer that the property is safe to conduct an inspection, and the seller is supposed to provide utilities to the extent possible. Obviously, if the power is out, for those of us that went through Irma, we know the power was out for a couple of weeks in some places, and that was a difficult situation. But the buyer is allowed a post-casualty inspection once the property is safe, even if the power is not on. So the last little bit about NABOR's provisions is if there is a pending storm, which I feel like it should say pending casualty event, but pending storm, this is when we're in the box and we can't get insurance. If the buyer is unable to obtain hazard, flood, wind, or homeowners casualty insurance coverage at a reasonable rate again, or if the services essential for closing are not available, that's like the title company closed because the hurricane's coming, then the buyer or the seller can delay the closing until they can get insurance coverage or until the services essential for closing are available. So if insurance coverage or services essential for closing stay unavailable for 30 days, then the parties can terminate within 5 days after the end of the 30-day period. So NABOR does not really have a straight up force majeure clause. Like when we get to FARBAR here in a few minutes, you'll see what they define force majeure and other things. But NABOR is more interested in getting the deal done and keeping it together, I think, but it just does it in an odd way. Skip, you're asking what defines a pending storm. We always say if we're in the box, if we're in the cone. So when the news is putting the cone on the screen and we're in that cone and we're not going to be able, the insurance companies stop covering and stop writing policies. Sometimes the insurance company will say we're in the box. That's what pending means, in my opinion. Michael, you were asking if the seller does not have enough insurance to cover I assume the damage, can they terminate rather than repair? So if the property is uninsurable or uninhabitable, Michael, then either party can terminate before closing. But the seller is supposed to fix the property regardless of their insurance coverage under the NABOR form. It's actually quite a harsh result. Other questions about NABOR before I switch over to the FARBAR Force Majeure provision? Okay, it's pretty simple, I think. Force majeure under the FARBAR contract is, I think, cleaner. This one is, this is right out of the contract. The buyer or seller shall not be obligated to exercise or perform any right or obligation under this contract or be liable to each other for damages so long as the performance or non-performance of the right or obligation or the availability of services is disrupted by a force majeure event. So what does that mean? Basically, the contract is paused while the force majeure event is going on. And they give a really good definition of force majeure in the FARBAR contract. It's a hurricane, flood, extreme weather, earthquake, fire, other act of God, all these other things, including epidemics and pandemics, which by the exercise of reasonable, diligent effort, the non-performing party is unable in whole or in part to prevent or overcome. So hurricanes here, we can't perform, the title company is closed, the power is out, the buyer can't get their funds in because the bank is closed, the seller can't get the signing because the title company can't get to the office to get the DocuSign going. I will tell you this as I talk about some of these examples here. When Irma came through, we all were surprised. It was the first hurricane in over 50 years, and it was a tough situation, and the power was out, and we weren't ready. It was not as destructive, in my opinion, in the Southwest Florida area as Ian. But Ian, we recovered faster because we were ready. We had been through Irma, and Ian, while it was more of a flooding event, it seemed like the power came on much faster, and that's kind of the biggest thing. And the reason I'm bringing this up is it says in force majeure says the buyer or seller should not be required to exercise or perform any right or obligation so long as performance or non-performance of the right or obligation is disrupted. With modern technology and Starlink and DocuSign and remote notaries, even in the pandemic, it was really hard to get the force majeure, to get into the force majeure provision and say you could not perform. And in the pandemic too, people are saying, I can't sign, it's too dangerous to go outside, I can't sign, I don't want to come into the office. And between DocuSign and signing outside and mobile notaries, I don't want people to rely on the force majeure provisions to say, well, we can't close because something is unavailable. It's very difficult to be unavailable in the modern era. But sometimes we have force majeure events, and they do hurricanes and whatnot, and they do slow down the process. A force majeure event is deemed to have begun on the first day the effect of the force majeure prevents the performance, non-performance, or availability of services. So it starts when you cannot perform, and it ends when you can perform again. It's extended for a reasonable time up to 7 days after the force majeure event no longer prevents performance. So you would have a delay for the hurricane, and then plus up to 7 days to get things moving again. If under FARBAR, if the force majeure event continues to prevent performance for more than 30 days beyond the closing date, remember NABOR was beyond the force majeure event date, 30 days beyond the closing date, then either party can terminate the contract. And this is what you're looking at on the screen is a copy and paste out of the contract. I made some bullet points to illustrate that basically, like I said, you're on hold while the force majeure event is going on. If you can't get insurance or close because of the hurricane, everyone is paused. And like I said, the force majeure event starts on the first day the force majeure event prevents the closing from happening because of things like insurance, because the power is out, things like that. And you go 30 days beyond the closing date. And if you can't close, the buyer gets their deposit back. And with that, that's really, it's a simple section today, not a whole lot. I'm going to take questions on this or any other topic. If you want to unmute yourself and shout them out or type them in the chat. Nobody has any questions. Everyone understands force majeure. No other questions. Great. Then this is this is going to be a short presentation. I want to thank everybody for coming.
Sam, I think we're asking for clarification on forms.
The last two slides were FARBAR, Sherry. Yep. Okay. Other questions? All right. If nobody has any questions, then thank you for tuning in this morning, and we will see everybody on Tuesday. We got two more in my video series to go. Talk to y'all later.